May it please the court. Valeria Hendricks on behalf of the appellant, Maria Rivera, who is the plaintiff below. She is appealing the summary judgment entered in favor of the defendant, Highwoods Property, who was the owner of the property on which she was injured. The essential issue in this case is whether the condition of the landscaping bed is, as a matter of law, not a dangerous condition or is so open and obvious that Highwoods does not have a duty to maintain it, and that Mrs. Rivera's own negligence was the sole cause of her injury. This is called the landscape exception to the general rule that juries usually decide whether a condition is open, obvious, and dangerous, and whether the trial court and whether the defendant breached the duty to maintain that. The trial court relied on several cases which held that the landscaping area in that case was so open and obvious that the property owner did not have a duty to maintain it for walking through, is basically it.
In other cases, I mean, is this case distinguishable in any material way from the Universal Studios case out of the 5th District?
That is the essential question here, and I cannot tell from the opinion there how high the metal rim was around the tree planting area there. Another difference is that the plaintiff there acknowledged that she saw the tree and the planter.
And I've looked at photographs such as they are that are in the appendix. The digital copies are a little bit digitized. But this looks like it's a sidewalk to the main entrance of a commercial building, and the sidewalk's, well, maybe 5 to 7 feet wide, roughly, where this happens. And the real problem is that the mulch is maybe 2 or 3 inches below sidewalk level. So this person's problem is that what I'll call the boundary between the sidewalk and the landscaping. Is that right? Exactly.
And because of its mulch and because of the shape of the landscaping bed, it is impossible to tell whether the whole bed is mulched or if it's just, you know, lower in places other than.
Do I know from someplace in the record when those pictures were taken, or how it may have looked at the time of the accident as compared to the time of the photograph?
The plaintiff took some of the photographs right after the accident, a few days after the accident, and her expert relied upon that. Because
I guess my concern is, if I skip landscaping for a moment and just think of this in terms of a duty of a commercial landowner to maintain the sidewalk and entrance to their property, what we have is not a big hole. It's just that the mulch isn't quite the same height as the sidewalk, and I mean, there's an awful lot of sidewalks on Earth that look like this. Probably right here on this piece of property.
And I think that you're right. So maybe there might be some problem.
Is there actually a common law duty to maintain the level of landscaping adjacent to a sidewalk that is otherwise properly maintained, so that they're basically at the same level?
Well, I don't think, except for in Taylor, has that question been answered, and the plaintiff's position is that this is a question of, a jury question of whether to determine whether it's an open, obvious, and whether the defendant breached the duty.
Well, let me ask this. Would you accept as a general proposition, and I ask this because I can't quite tell from your brief, but would you accept as a general proposition that the difference in gradation between the sidewalk and the planting bed standing alone would not be sufficient to get you to a jury on this? In other words, I sense from your brief that you are accepting that proposition, but you don't really come out and say it. Just that landscaping beds are open and obvious enough that if you step into one of them, landowner not liable for the condition of the bed.
Okay, assuming the truth of that. In this case, there's evidence that because of the way the property was designed, the entrance from the parking lot was designed, it created kind of an illusion of a straight path, but in order to actually get to the building. This
is the expert's competition for focus theory, right?
That's exactly right.
Okay.
Setting all that aside, if you could, because that was one of the questions I was going to ask you, Judge Solero's question. Putting all that aside, by virtue of the fact that the landscape is a little bit the gradation different, that by itself is not a dangerous condition. Would you agree with that? Taking just that in its own, without all these other factors that you're injecting in this case.
As a matter of law, I would have to say, as a matter of law, the property owner did not have a duty to maintain that landscaping bed with mulch to keep it even with the sidewalk.
Was the motion for summary judgment, by the way, based solely on the case law that says there's no duty for landscape area, or was it based on this not being a defect as well?
Well, I think it was based on the cases. That's where they got to the point that this was not a defect, based upon the landscaping cases, which, as I stated in the brief, most of them aren't applicable when they're dealing with failure to warn as opposed to failure to maintain. Second, and most glaring, is the plaintiffs in those cases walked through the bed. Now, if Ms. Rivera were walking through that bed, then I would say there's no duty to maintain the mulch. But if, as her expert testified, and we are on summary judgment, that this created a dangerous condition on the property that the landowner could have fixed by, in some of the...
Well, the expert said that there was, the quote is, I think, foreseeable competition for focus, right?
Right.
And a couple of questions about that. One, what was the competition for her focus? Just the fact that the entrance was across from the planter? I mean, that it was in her direct line of sight?
I think it was the design of the planter jutting out kind of in front of the office building. And I think that first or second picture shows that behind this particular planter was another planter with a curb on it. I mean, it was curbed, so you really couldn't trip into it unless you stepped on it, basically.
Make sure I understand from the photographs. As the photograph I saw, there's like an ADA ramp at a curb that you would probably walk up, and then there were beds on the left side and the right side, and I'm assuming that the spot where she fell was on the right-hand side. Is that correct?
I think you're right. Yes.
She may very well have lost her balance, and there was another bedding in front of that had a curb on it that may very well be what she hit her knee on or something, I suppose.
Well, I think it's the curb, the actual walkway itself that she hit her left knee on.
Okay.
And how, tell me a little bit about how she was carrying stuff?
She was carrying stuff, but there is nothing in the record to suggest that the stuff that she was carrying blocked her view of the sidewalk.
But she was joking with her friend, right? I mean, her attention was on her friend, and she was joking with her friend about how it was the friend's turn to start carrying stuff, right?
Right.
So why, I guess that brings me back to where I started, why is this in any way distinguishable from the Universal Studios case? You know, I suppose she may have been aware of the planter, but she's at a theme park, there's other things competing for her attention. She walks into a planter, and the Fifth District says summary judgment properly granted.
Right. I think one of the things in Taylor, I think it is Taylor, the plaintiff acknowledged that she saw the tree and the planter before her fall, and she was not looking where she was going. Although the plaintiff here was talking to her friend and was carrying stuff, she did not admit that she saw this ledge, I guess, of the planter. Again, I don't know what the planter at the Universal Studios looked like. I mean, it says that it was a terrazzo sidewalk and it had a metal rim coming up. I don't know how big that metal rim is. They also said that it is glaringly open and obvious obstacle for anyone walking either on the walkway or the street. Taylor should have known or knew that she was walking into the planter. That case, respectfully, the Fifth District basically made a factual determination. It discredited the plaintiff's expert, the only evidence there. And I think, and I would argue, that Judge Sharp's dissent is more in line with the actual case law. I know that's a hard argument to make, but I think it's true.
Yeah, well, and I guess to that point in this case, as I read the expert's affidavit, his analysis about the competition for the plaintiff's focus is really just appending the word foreseeable to it. And one of the questions I had is, our summary judgment standard is what it is, but don't we deal with a little more substantiality than just a label of foreseeability to create a genuine issue of material fact?
Your Honor, I think he buttressed that foreseeability argument with his determination that her eyesight was competing for, there was a focal competition between the building and the landscaping bed. And I think because the affidavit, the expert's affidavit itself, was not challenged in any way on sufficiency, then I don't know how the trial court could make that decision without something to back him up. And I don't think he made that determination. I know that he said, well, without this expert opinion, you would probably pretty much be sunk. But it's my position, and I think the case law supports this, that you can't make a determination of credibility or weighing the expert's opinion on a motion for summary judgment. If the court has no more questions, I respectfully, on behalf of the plaintiff, request the court to reverse the summary judgment and remand for further proceedings to trial. Thank you.
We'll save you 5 minutes for rebuttal.
Yes.
Hear from the appellee.
Thank you, Your Honors. Good morning. My name is Bora Kayan. I'm here on behalf of Highwoods, the appellee. Much of the discussion has already taken place. Obviously, the case is simply about whether or not this is a dangerous condition and or is a landscaping feature that the 3rd, the 4th, and the 5th DCA have all carved out an exception for as to not being a walkway or place intended to walk, whether it be the edge we would submit to the court or whether it be the actual mulch in the flower bed itself or the landscaping feature itself. I believe the squarely falls, as mentioned by you, Your Honor, about Taylor versus Universal. This is almost the exact factual base that we have here before you again today. This is dealing with mulch again.
For the moment, change our facts to a hypothetical.
Sure, Your Honor.
And instead of having this 2.5-inch drop off in this spot, let's say that somebody had dug a hole to put in a post or a light and it was 18 inches deep there and about this big, and that's what she'd stepped in. But still in the landscaping, is there still no duty for that?
Your Honor, from the cases that I read, and it would seem to indicate that that would not be an issue, even no matter what was in that hole, whether it be a hole that deep, like you're mentioning, whether it be something dangerous like alligators or sharks in the bottom of that pit.
Doesn't make any difference.
Doesn't seem like that to me. And I've read these cases backwards and forwards several times.
Does that make any sense to you?
Personally, I don't like it.
Okay.
So I understand that part. But here we're dealing with a drop off into mulch of only a few inches. Very similar to what's in Taylor. And although counsel argues that there should have been a border of some kind around this edge or this curb, that doesn't mean that she may not have fallen anyway. As in some of the other cases pointed out here, that there are edging that still.
We would have a duty to warn about that hole, wouldn't we?
I guess we'd argue, we still kind of do whether it's a hidden danger or not. Is it open and obvious, or is it hidden danger?
Neither of the parties cited it, but for your own personal entertainment, if you go back and read a case called Bryant versus Lucky Stores from about 25 years ago, it's the last time this court ever went en banc in a courtroom, and hopefully we will never do it again because it was a zoo. But it was a grand fight about whether a speed bump in a Winn-Dixie or parking lot was an open and obvious condition when some old lady tripped over it. And we went all which ways on that. And part of the problem is that all of this open and obvious stuff goes back to the days of contributory negligence. And it doesn't quite fit with modern comparative negligence.
Yes, Your Honor.
And so it seems to me that at least at some point, it's not that there's no duty owed, it's just that there's no breach for some minor things. And the question is this one so clearly minor that it's not a jury question?
I believe it is, Your Honor. I believe Judge Barton felt the same way after reviewing the cases. I mean, unfortunately, there are no cases that we can look at and say the courts went the other way. As you mentioned in your imaginary case, that there was a bigger hole there, a bigger hazard there, would that make an issue? All the cases that I've found from the 3rd, 4th, and the 5th indicate the other way, whether it be someone's falling into said feature, whether it be someone's crossing the feature, willingly going to McDonald's like in the Owens case, or the Dampier case, excuse me, or whether it be someone simply falling on the edge of a feature, like the boy in the KG Evangelical case, unfortunately, trying to catch a football and hitting the curb of the bricks that are around that planter there too. The courts have also even gone so far as to say whether or not that planter or the feature is actually perceived or not seems not make a difference either. So I guess, unfortunately, going to your other case about the hole being there, I think that those courts may have still found that there's no duty there, unfortunately, to say that this is a deep well or something.
Okay.
In any event, I believe that plaintiffs testified, as noted in the record, as to what she was doing. Her observations and her perceptions were obviously challenged by her carrying objects, her talking to her friend, not looking at where she was going as part of the problem. The expert's affidavit and the expert's opinion, I think, although he has not been deposed, can be dismissed in this case in the scheme of she's not even looking there towards the door that he believes is causing the issue with her perception of where she's going to be walking to next. She's obviously not looking where she's walking to next because she's doing other things. Her attention is distracted from what else she's planning on doing. Her car, in fact, she testified, wasn't even parked in a parking spot because it's full of objects as she's moving into the building, and it's even parked against the curb right there, a few feet away from where she falls to. There's a million things most likely on her mind, so the way she testified as well. It's an unfortunate accident that has happened to her, but at some point in time, you got to be looking where you're walking. You got to be looking where your left foot's going in front of your right and be able to judge where you're stepping. Unfortunately, she stepped in the mulch here. And I really don't believe a curb in this case would have made a difference, no matter how high or low this curb would have been. So we believe that Judge Barton made the right ruling based upon the case law that we have. It's before the court as well for the 3rd, 4th, and the 5th. Thank you.
Okay. Ms. Hendricks, any rebuttal?
I think the question whether the border around a higher curb around the border, or whether the border was open or the level of mulch was different, which caused or contributed to the plaintiff's injuries, is a question for a jury, not a question of law under the facts of this case. And I recognize that Judge Barton ruled the way he did because of the prior cases in the 4th, 5th, and 3rd, and he felt like he had to follow him, but he wanted the 2nd District to maybe issue some guidance in this district for such cases. And Judge Altenburn, with respect to Bryant, I can't remember if it was a speed bump or a parking stop.
It was a speed bump. There was dark tar and was not painted yellow.
I recall the case very well. I mean, I recall the en banc decision very well. But in this case, summary judgment as to the existence of the property owner's duty should be reversed for a jury determination of whether he breached that duty or whether it was an open and obvious condition.
And as I hear you, you said earlier what distinguishes this case from the 5th is that you said in the 5th, the plaintiff there admitted seeing, and in this case, you're taking the position it's a little bit different because there was never an admission on the part of your client.
Exactly, and I think that when you read the record in the light most favorable to the plaintiff as the non-moving party, I think the conclusion is inescapable that this is a jury question.
Putting to the side the question of whether or not, you know, we are going to follow the cases from the other district that create the so-called landscaping exception. I mean, is the proper legal rule here that a landowner has no liability for failure to maintain in a reasonably safe condition for open and obvious dangers unless the landowner should have foreseen some other danger that could cause the injury? I mean, is that the basic principle that we've got to apply?
That is the basic principle. Yes,
Right.
It is.
And if that's the principle we've got to apply, I mean, it sounds to me like the landscaping feature is open and obvious, and the question we've got to resolve is this issue with the expert's testimony about focal competition sufficient to get you to a jury? Is that right? Or?
That is right, and that is the position. Like you said, whether an owner should be liable if the evidence shows that the owner should have anticipated the harm despite the obvious and known nature of it. And I think that the plaintiff's expert's affidavit clearly creates a material question of fact on that.
Okay.
If there's nothing else, thank you so much.
Thank you.